Hi, it's Dwyer, richarddwyer.co, also gamblersadvisory.com. Let's talk about David Geffen. Let's talk about his divorce case without a prenup to a spouse who he's been married to for about 2 years, right? Who might not have the net worth, the assets, the wealth that Geffen has. There might be a huge, meaningful wealth disparity between the two of them. Now, let me point out that my office is located at Mountain View, California. I sometimes prepare premarital agreements for high net worth individuals. I sometimes handle high net worth divorce cases. Now, I want to be clear here to everyone watching this video. It's very important to get this point because I know there's a difference of opinion online. In my opinion, you are always better off with a premarital agreement, right? Understand, in California, you are going to be married pursuant to an agreement. Either the state's default agreement involving community property that's based on statutes or case law, or you're going to be governed by an agreement that you and your fiance customize to meet your situation. There is no possibility in the state of California for you to get married without being governed by some set of rules. My advice to everyone watching this video is that you consider setting the rules with your fiance yourselves, putting them in writing, a writing that fulfills the requirements of California Family Code Section 1615, which has procedural hurdles, right? The parties, for example, must be represented by an attorney, right? Independent counsel for each. If the waiver of spousal support that they might choose to put in a premarital agreement is to be enforceable, right? Understand too, California law requires that the parties have the final draft of the agreement a minimum of 7 days. Again, this is Family Code Section 1615, right, before signing the agreement. So this isn't a happenstance thing where a couple 2 days before their wedding decide that they're going to have a premarital agreement and then write something up that both of them sign. No, you need counsel to have some of the provisions be enforceable, and you need to follow the statutory protocol. Now, let me point out that for high net worth individuals, sometimes emotions will prevent them from talking fully with a fiance who they're in love with about a prenup, right? It happens to all of us, right? You know, you can be poor, you can be wealthy. Sometimes you understand that if you start talking about a prenup with someone who feels that you're trying to limit what they can collect under California law, the relationship itself might be in danger, right? But I need for folks to understand that high net worth individuals have some needs that are different from everyone else's. Sometimes a high net worth individual doesn't want to disclose in any document their assets and debts. Sometimes a high net worth individual might feel that a disclosure of their assets and debts might trigger a tax audit. If you're going to enter into a legally binding premarital agreement in the state of California, you're going to have to disclose your assets and debts, right? So for that reason alone, a lot of wealthy individuals shy away from premarital agreements that quite frankly would help them protect their assets. Right now, whatever David Geffen's reasons, he decided not to get a prenup for his marriage. Folks, I think because he's retired, because I believe he's savvy, right? He used to be a manager. He, has been very successful shepherding other people's careers. He knows the value of contracts. No doubt he has access to excellent lawyers. I'm sure he has thought things through. Let's try to give everyone an edge on California law here, right? Let's say you're discussing getting a prenup with your fiance. My advice is to get one, right? But if for whatever reason you decide not to get the prenup, right? Let's just say the weekend in Las Vegas was that good. Whatever the reasons, right? Just understand that if you're a high net worth individual, California Family Code Section 770, let me repeat that. California Family Code Section 770 is your best friend if you know how to structure your affairs. Now, under this statute, look it up, the separate property that you own before marriage remains your separate property. Let's go further. Let's say I own NVIDIA stock before I get married. Then I get married and NVIDIA stock splits. There are dividends. There's a lot of capital appreciation during marriage. If I've structured my estate the right way, where I have not mixed, the legal word is commingled, my separate property with community property money. If I haven't made that mistake, and if that weekend in Vegas didn't lead me to sign paperwork under Family Code Section 852, again, Family Code Section 852, where I transmute my separate property into community property, right, in a statutorily compliant writing. If I haven't done anything like that, then all of the dividends, all of the capital gains that my separate property accrues during marriage is my separate property. Believe it or not, that's without a premarital agreement, right? Let me also point out, too, that if I get an inheritance, let's say I'm wealthy because I came from a wealthy family, right? Under Family Code Section 770, that inheritance, provided it's to me, right? Provided whoever is giving you the inheritance, it could be a sibling, it could be a grandparent, it could be your parents. Sometimes grandparents, parents, siblings try to be folksy and say to Joe and his wife, you don't want that. As long as they say to Joe and don't include your wife, as long as it's your inheritance and there's no argument an attorney can make that the inheritance was given to both you and your spouse, your inheritance, and this is without a premarital agreement, is your separate property. The same applies to gifts you receive, right? Again, make sure the gift giver doesn't try to sound folksy and say to Joe and his wife, right? You want the gift to be to Joe, period. You want no reference to your family being made in any gift document. Again, under Family Code Section 770, that gift would be your separate property. Understand what you have to do to have separate property. You have to treat it a certain way. So let's say someone gives me $100. I can't deposit that money in a joint account I have with my partner. Right? I have to put that $100 in an account that only I have signatory rights on. In other words, I have to keep my separate property separate. If I do that and then get a divorce, and it doesn't matter who files for divorce, it could be me, it could be my spouse, right? If I have kept my separate property from before marriage, as well as inheritances that I received during marriage and gifts I received during marriage, then it's all mine. All I have to do is say, look, here is the will. This was given to me, right? Here are the account statements, and you want to keep all of your account statements, right? Don't trust, banks that have your statements online, right? Because understand, banks go under. Where's Washington Mutual today? You always want hard copies, always, of your separate property financial accounts. Right now, understand, this is harder than it seems because you're living with your spouse. Right? The two of you haven't agreed to this because you're flying without a premarital agreement. Right? Against the advice of attorney Richard Dwyer. Right? You're flying without a premarital agreement. But just understand the state of California, the state legislators who make laws that are binding on all of us, this is the legal setup that they have created. So, I know it's going to sound dodgy to many, right? You have a spouse, but yet you have a private set of documents that you are privately maintaining. Your spouse is going to think you're having an affair if she finds out, or he, whatever your deal is, that you have your own bank deposit box, right? But you need to. Because understand, the burden of proof is on you to show the separate property you owned before marriage. That falls under Family Code Section 770. Right? The burden of proof is on you to show the money you got pursuant to an inheritance or pursuant to a gift. Let me tell you how dodgy some divorces get. The people who will give you gifts late in their lives are older. They might have problems remembering what they did last week. The burden's on you to show their donative intent. And it's dodgy because you can imagine. You have a divorce case, you subpoena the person to show up for a deposition. Right? Your spouse of several years has their attorney at the deposition. Your attorney says, Grandpa Joe, you gave this money to my client as a gift. Is that correct? Right? Grandpa Joe might say, yes, it is. You hope Grandpa Joe understands the question. But understand, your wife's counsel And again, you and your wife may have been in a multi-year marriage. Is going to say, didn't you intend to give this gift to Joe's family? Not just Joe, but Joe's family. Wasn't it your intention for Joe to spend the money on his wife, on his kids, on your grandkids? Right? Wasn't it your intention, in fact, to give some of this money to your wife? Didn't you want the family to receive the money? I'm telling you, sometimes relatives get turned around. Right? Sometimes the money that's been given is substantial. Think it through. Let's talk about another statute. And this is probably the most important statute in the David Geffen case, other than Family Code Section 770. This one is Family Code, and again, this is California. All of the statutory references I'm making here are to California Family Code sections. If you're in a different state watching this video, or a different country, a different jurisdiction, understand these laws might not apply to you. Right? Family law is really a state by state creation. California is a community property state. Right? The statutes are created by the California state legislature. Your legislature might see things differently. Let's talk about Family Code Section 4320, subsection L. Again, it's 4320, subsection L. Now understand, under this section, spousal support in marriages of less than 10 years typically runs for half the length of the marriage. Again, it's Family Code Section 4320, subsection L. Right? Now, understand, I say they typically run for half the length of the marriage. Courts have discretion. You better hope that your spouse doesn't become disabled, physically or mentally. Right? I had a trial where a client was on SSDI, and we were able to get him long-term support. Right? His wife is going to have to pay support unless the court changes its mind. If my client somehow loses his disability insurance, his disability status, there's that possibility. Right? If something happens to her, the payer, let's say she gets hit by a car, let's say she can no longer work, her earning capacity evaporates, then understand courts have the discretion to modify prior rulings. But understand, assuming that David Geffen's younger spouse is healthy, right, is able to work, might even be working, because it's only a 2-year marriage, David Geffen should be able to get out of the marriage paying temporary spousal support for only half the length of the marriage, right, for 1 year. This is without a prenup. Now, much of the public seems to believe that if I'm a millionaire and I get married, suddenly my spouse owns half of everything I own. That's not the case, right? As you're finding out, the separate property that I own before marriage remains my separate property under Family Code Section 770, unless I decide to transmute it, right? Or do stupid things like commingle it with community property, right? Be careful anytime you open a joint account. Be careful anytime you're dealing with a title deed and the thought of putting your spouse's name on the title deed even crosses your mind. Right? Be careful. You want things titled, things that are yours, particularly things that are yours from before the marriage. You want them to continue to be in your name alone. Right? You want no presumption of joint ownership. Right? With a right of survivorship. Understand too, and this doesn't apply to the David Geffen case, at least I don't think it does. But if a couple has children, then the game's changed. The rules changed. No kids, spousal support runs for half the length of the marriage for marriages that are less than 10 years in California, right? Marriages that aren't what's called long-term marriages. But if you have kids, your spousal support obligation runs until your youngest child's high school class graduates. Right? Don't get me wrong. Your kid could be one of these delinquent kids where the class graduates but he doesn't graduate. Right? But understand, as long as his class graduates from high school, then your child support obligation extinguishes itself. Right? So even with a prenup, understand in California, any agreement that allows a parent to pay less than guideline support is voidable. So California prenups really can't address the issue of child support. Understand too, you can put flowery language in a premarital agreement where the two of you agree that in the event that you get divorced, each parent will have 50% custody of the children. Folks, if that's not in the best interest of the child, if there's any hint of domestic violence, look up Family Code Section 3044. The court's not going to enforce that 50-50 physical custody provision in your premarital agreement. Right? So just understand, children change the game. Now let's get hard here because life has rough edges. If you're married in the state of California for 10 years, then you have a long-term marriage, assuming there's no date of separation before the 10-year mark. Right? Understand, with long-term marriages, marriages of 10 years or more, the court has indefinite jurisdiction under Family Code Section 4336. Again, 4336. And these statutes are online. You can Google California Family Code Section 4336 to award spousal support. So understand what this means. If you and your spouse are having problems at the 9-year mark, you need to seriously consider, depending on the severity of the problems you're having, filing for divorce. Right? Understand, in these situations, there's always an argument over the actual date of separation if the I want a divorce talk was not put in writing. But there's no dispute on the filing date of a petition for dissolution. Right? The court will stamp that document. If it's within 10 years of marriage, then you can argue that your date of separation was within 10 years of marriage. Right? If your marriage is on shaky ground at the 9-year mark, you seriously need to consider getting out of it. If you only want to be liable for spousal support for half the length of the marriage, 4.5 years, as opposed to having the court having indefinite jurisdiction over spousal support. What that means is that, let's say your spouse is making more than you, but she loses her job, as has been happening here in the Bay Area, right? Meta has let people go, Google has let people go, Microsoft has let people go, right? Your spouse could be bulletproof, find herself unemployed, right? Understand, long-term marriage, the standard for spousal support is the marital standard of living. Let me also make another point too. Let's say your spouse can no longer meet that marital standard of living. She hires an attorney. That attorney, under Family Code Section 2030, can come after you for their legal fees. Both sides are likely to hire a forensic accountant to calculate the marital standard of living. Right? Typically what they do is they look at the last 5 years of marriage. They look at the tax returns that the parties filed. Sometimes it's joint tax returns, right? They look at, extrinsic facts. What were the spending habits of the family? Did they go on vacations? Where did they go? And things like that. Right, folks? You can avoid this. If you're having problems in year 9 and you decide to file for divorce in year 9, as opposed to waiting after the 10-year mark. Because if your spouse loses her job 5 years after the end of your marriage, she can go back into court and get spousal support from you. Right? Again, that's Family Code Section 4336. You'll find that it's an abuse of discretion for the court in a long-term marriage not to retain jurisdiction over spousal support initially. Right? Now let's talk about special circumstances involving people going forward without a prenup. First thing, you want to make
Let's Chat is no longer available. For now, you can ask me questions or to do things like set a timer, play music, turn on a connected light.
Alexa, off. Forgive the interruption. Right? Make sure that none of your real properties carry a mortgage that will be paid off with community property funds. Right? That's a big one. Again, make sure that none of your real properties, in your name alone, carry a mortgage that you plan to pay off with community property funds. If they do, and if they carry a traditional mortgage, not an interest-only mortgage, then understand the use of community property funds to pay down that mortgage debt would allow the community to obtain an ownership share of the property equal to the percentage of the decrease in the principal on the mortgage, as well as a proportionate share of the appreciation of the property. So, if you have mortgage property, make sure you can pay down the mortgage with your separate property. So again, if you owned NVIDIA before you got married and you kept NVIDIA in its own account, right, in your separate property account, when your mortgage becomes due on your separate property real estate where only you are listed on the title, you can pay down that mortgage with your own separate property. Under no circumstance should you use your community property to pay down that separate property mortgage. Right? The interest is called a MORE, M-O-O-R-E, Marsden, M-A-R-S-D-E-N. Again, M-A-R-S-D-E-N, interest in the property. I'm assuming David Geffen has his properties free and clear. Right? As long as he's not using community property to pay down any mortgage debt, and as long as he's not using community property money to pay the carrying costs on the property, In other words, property taxes and things like that. Repairs on a separate property, right? You don't want to remodel your separate property real estate using community property funds. As long as he hasn't done anything like that, then the community should not have an interest in his separate property real estate. Right? Let me say this too. You have many high net worth individuals who own businesses. Right? Now, these are the conversations I have with some people. Right? I tell them, you know what? You'd be better off owning stock. In other words, you'd be better off closing your business, particularly if it's a vanity business. Let's say you have one of these businesses that means a lot to you because you remember when you were eating beans and rice and canned tuna, and this was your little business. It doesn't really kick off a lot, but you don't want to give it up, right? You're better off shutting down that business, diverting your wealth to S&P 500 stocks, NASDAQ stocks, because of the liability that can be argued by your spouse's attorney concerning Van Camp and Pereira case law in California. Again, it's Van Camp and Pereira case law. Right? Understand, with Google, it's obvious that you're not running the company. No one can claim that you should be receiving a reasonable salary for doing so. Right? You know the way a lot of these hotshots do it. They don't take a salary from their business. They're just relying on capital gains. Right? The business is really a vanity thing that allows them to say president of, Ron Brown Enterprises or what have you. But here's the problem. You're in a divorce proceeding and your spouse then says, you know what? He should have been receiving a reasonable salary of $100,000 from his business. Not only that, he worked on his business. Let's say you traveled to a few locations, gave speeches, used the business for a tax write-off, to attend seminars in Las Vegas, and stuff like that. Understand, that doesn't play in court. Right? People hear that you owned a business, they're going to try to impute a reasonable wage to you. Right? $50,000 a year, $100,000 a year. Right? You're going to have to spend money on an accountant to say, no, the business didn't make that much. But the argument is going to be that any effort you put into a business during the marriage was a marital asset. You should be compensated for it. Again, it's Van Camp Pereira. Right? So let me say, if you own a business that you can't convert into, normal stocks, you need to make sure that that business is operating without you, that it's fully staffed, that you're doing no work for that business, that you have hired management who are doing all the work for that separate property business. And of course, any bills that come up for that business, right? If the business needs a capital call and you need to invest more money, it can't be community property money. It has to be separate property money. Otherwise, you're going to get hit with arguments that you should have been paid for your role in shepherding this business, right? And that you use community property on the business, so the community now owns 10% of the business. Let me make another point too, and it's going to sound cruel to people. Again, life has rough edges. You cannot have your spouse working for your business. Because if the business doubles in value, the spouse is going to claim that it was because of their efforts. Folks, it's messy in court, right? You're going to have experts come in and talk about how the business doubled in value because of the inflation rate in the general economy. Because the business operated in a niche where the entire niche jumped in value. Your competitors jumped in value, right? Semiconductors are popular now, right? The semiconductor industry jumped in value. Just understand that the minute your spouse works for your business, you are at risk of the spouse claiming that they're responsible for the upside in the business. Also, that they were underpaid and did not receive the fair value of their work effort. Also, you have, in divorces, a lot of areas where people disagree, where you start hearing about alleged promises that were made. If your spouse never worked for your business, it's hard for them to claim that you told them that, they had a job for life in the business. But the minute they work 2 days in the business, they can start making claims like that, right? So if you own a business, make sure it's fully staffed. Make sure you put no time and effort into it. The argument is that it was operating without you. It's kind of like having a blind trust and being a member of Congress, right? It was its own thing. No marital assets, including your time and effort, were put into the business. Your spouse, even if they're interested in the business, even if they want to work for your business, I'm just telling you, it's not worth it if the relationship could possibly be headed for a divorce. Let me make a few more points. I see I'm already at 37 minutes. Of course, never use any community property, money, or assets for any part of your business. Understand, if you have a home business, and if the home is community property, right? If your spouse's name is on the title for the home, right? Then, of course, in a divorce, they're going to say, hey, the business should have been paying rent for being located in the home, right? If you have a business separated from everything community, including the community family residence. Let me say too, you want to never put your spouse's name on the title of any real property that you own. Right? The minute you do that, there's going to be a question of fact that would have to be decided by a judge on whether you gifted your spouse half the equity you own in the property. Let me also say too that you need to think about and be wary of retirement account contributions during marriage. Right? Often people get married, they have retirement accounts, and they say, hey, let me continue, I'm getting favorable tax treatment, let me contribute to my retirement account, right? And they'll sometimes use joint accounts to do so. Folks, that's foolish, right? If you use community property to make contributions to your retirement account, guess what? Part of your retirement account is community property, right? You're going to have what's called a qualified domestic relations order done on the retirement accounts. That's a quadro, right? And that opens the door, of course, to what you don't want, expert witnesses in a divorce trial. Not that retirement experts cost that much. So you need to think hard about any retirement account that you plan to fund during marriage, right? If you make a contribution, it has to be with your separate property money, right? My advice is if you're going to get into the world of maintaining retirement accounts during your marriage, then you should have a prenuptial agreement. Let me also point out, too, that you don't want to receive bonuses shortly after your date of separation. Here's what happens, right? You and your wife separate, and then you receive a severance package, right? Your employer is grateful for 20 years of service, and they reward you with a severance package. Well, understand, your spouse's attorney can then say, well, part of that severance package is compensation received for time he spent at that company during the marriage. We're entitled to a part of that. Right here again, if you're operating in the world of bonuses and severance packages, my advice is to get a premarital agreement where your liability is spelled out, right? Or it's to structure your affairs in such a way where you're retired, where you're not funding a retirement account. You're not using community property for anything, right? You are, maintaining all of your separate property with your separate property, right? Your income is minimal. Those are my thoughts. Let me hear yours in the comment section of this YouTube video. I know family law sounds intimidating. It sounds more complicated than it is. In essence, you want your separate property to stay separate. You want there to be as little community property as possible in a premarital agreement. You can structure your premarital agreement where postmarital wage income is deemed to be separate property, but the parties have joint accounts they designate as joint, where when they put money into that account, that money becomes community property, right? So they can have a community property fund for groceries, utilities, vacations, the kids' private school education, while also maintaining their own separate property, including the money they use for retirement contributions. Those are my thoughts. Let me hear yours. I'm sure David Geffen had this all figured out and entered the marriage with his affair structured where his separate property was easily identifiable. And of course, he's getting out of the marriage early enough where it looks to me like he's only on the hook for half the length of the marriage in terms of spousal support liability. Those are my thoughts. I look forward to yours. Thanks for stopping by.